Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about post-arrest statements made in the context of an allegation of recent fabrication. Cases that should have gone to the Supreme Court of Canada, but didn't. Oftentimes, when people are arrested, they make the mistake of saying something after their arrest. And those statements, provided there's not a charter violation or an issue with the voluntariness of the statement, could be admissible against the person as evidence. Sometimes those statements may contradict what the person says in a later police interview, or what they say as their testimony in court. And a question arose in a case about the extent to which a post-arrest statement could be used as evidence of recent fabrication. It's a very important issue because when you're talking about somebody who's in the context of having recently been arrested, there's a lot more that's going through your mind in that moment than what might necessarily be going through your mind when you've had the time to sit down, calm yourself down, obtain some legal advice, understand the true nature of the charges against you. To just be stopped in the street, for example, and be arrested for an assault, or to be pulled over and arrested for impaired driving, is very different psychologically than circumstances where you may be actually sitting at the police detachment and giving a statement, or testifying on the stand where you have a better understanding of the case against you. You may make a spontaneous statement after your arrest based on a flawed understanding of what the actual evidence is. And so courts should be very cautious when using post-arrest statements as evidence of recent fabrication in other testimony or other interviews. And unfortunately, the Supreme Court of Canada, I think, didn't notice the opportunity here to really delve into what we're getting a better understanding of in our legal system, the power imbalance between police and individuals, and the way in which their statements, especially made in the immediate aftermath of an incident, to the police can potentially be unreliable and not just fabrications based on a person's desire to mislead. Hopefully the Supreme Court of Canada does take another opportunity to look at this issue and recognize that that power imbalance can lead to statements that are not accurate, that are made in the heat of the moment, out of panic, and aren't representative of maybe the truth of the matter. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.